Hello, my name's Evan Chandler, and my case is about cyberstalking harassment. My victim her name is Hannah Montana. She's 24 years old. She's 5 feet 2 inches. Weight is 110 pounds. Occupation is a fast food worker. Her address is 123 Fake Street. Her telephone number is 231-456-7891. Her address to place of work is 123 Fast Food Street. And her phone number of place of work is 123-123-4567. And the suspect is Ronald McDonald, a.k.a. Biggie Smalls. His age is 36. Height, 4 feet 9 inches. Weight, 320 pounds. Occupation, unemployed. Address, 123 Guilty Road. He lives in his mother's basement. Telephone number is 123-123-5678. Additional information is he is currently on parole and has a tattoo of Thug Life on the right side of his neck. And I added the victim and the suspect information because if I was investigating this crime, I would definitely have all the victim information first. That way, if I needed to get in contact with her later, I would have all of her stuff. If I couldn't get her at her home, I could get her at her work. That's why I would have her work where she works and her phone number. The scenario is that the victim, Hannah Montana, received 2 emails and 1 Facebook messages, all of them very threatening in nature. The first email happened on October 1st, 2014. The email stated that my Big Mac meal did not come with extra large fries. For that, I will hunt you down and kill you. The email was sent from the username thuglifeforever@yahoo.com. The victim at this point ignored the email and moved on with her life. But then a second email arrived on October 2nd, and this one was more threatening. It was again from the same username of thuglifeforever@yahoo.com. It was more threatening, and it says, when you come home from work, and it had specific instructions in this email. It says, when you come home from work, place a bag of large fries in the mailbox. If they're not there, we'll kill you and your whole family. I am watching you. Hannah, being fearful of her life, did what she could and brought home the large fries and put them in her mailbox. And the next was Facebook messages on October 3rd. And it was from the username Biggie Smalls. And this one was, again, instructions on leaving McDonald's a Big Mac in her mailbox when she came home from work. And it said, I know where you live, and I always follow through with my threats. And it goes on to say that he will kill her if he doesn't do it. And then I analyzed the crime and the history of the crime. And cyberstalking is a lot like common physical stalking and harassment. The only real difference is that in cyberstalking, there isn't that physical contact. And common stalking, that will be actively following the suspect, the victim. But the real issue with cyberstalking is that because most people are connected with the internet on their daily life, that cyberstalking intrudes on their everyday life because most people use the internet for everything. So cyberstalking would be always following that victim. And in 1996, Congress passed the Interstate Stalking Punishment and Prevention Act. And there's a Michigan Penal Code 750.411 state that is a crime to conduct arising from posting the message causes the victim to suffer emotional distress and to feel terrorized, frightening, intimidated, threatened, harassed, or molested. So our victim had suffered emotional distress and did feel terrorized because she was receiving threatening and intimidating messages. And why is it considered a cybercrime? Well, the Michigan Penal Code 750.411 describes harassment as a means conduct directed toward a victim that includes but is not limited to repeated, continuing, unconsented contact that would cause a reasonable individual to suffer emotional distress and that actually cause the victim to suffer emotional distress. Harassment does not include constitutionally protected activity or conduct that serves a legitimate purpose. The emails to the victim were repeated and were intended to cause fear and intended for personal gain for the McDonald's in the mailbox. And again, the Michigan Penal Code describes stalking as a means of willful course of conduct involving repeated or continuing harassment of another individual that would cause a reasonable person to feel terrorized, frightened, intimidated, threatened, harassed, or molested, and it would actually cause the victim to feel terrorized, frightened, intimidated, threatened, harassed, or molested. And the steps and techniques that I would be used in investigating the cybercrime is first you would go talk to the victim, figure out what was going on, question her, and then I would get the IP address from the emails that were sent to her, the Thug Life Forever, and try to retrace those. And I found a thing on Google where law enforcement has to get a subpoena, ECPA court order, or a search warrant, and then would have to contact Google or Yahoo in that scenario. Would have to contact them and try to retrace the steps of that IP address. And investigators have to show that the trace will be used in gathering potential evidence that could be relevant in an ongoing criminal investigation. So we will be gathering all this information and trying to get a search warrant. We would copy the emails and the Facebook message. And the Facebook message, what you could do is if the Facebook message was Facebook profile was, the suspect's Facebook profile was on public, the settings, privacy settings were set for public. You go on there and there's usually a lot of good information where a lot of personal information, where address, phone number, date of birth, things like that, where you could gain additional information on the suspect. And then I found that in the case of the United States v. Charbonneau, the Supreme Court ruled that undercover operations are legal in chat rooms, and Facebook is a public forum. So law enforcement could use undercover techniques on Facebook to gain more information for the potential suspect. So before the search warrant was issued, we could go in there and try to gain some more information via undercover operations from the suspect. And now, we're on to explain how to properly identify, seize, extract, analyze, and report digital information that can be used as evidence as a crime. So once we have that search warrant, we would go ahead and go in there with our evidence kit. I have my evidence kit that I made. So once I have my evidence kit, go in there with our evidence kit, which has everything that we need. Our pad of paper, our rulers. We would go in there with a search warrant and first we would take as many photos as we can of all the evidence that we have, any laptops or anything, any digital computerized technology piece that they have that the suspect had access to would have to be photographed and put as evidence. And the drive openings to the computer-based items would be sealed to prevent contamination. Faraday bags would be used for wireless devices. If electronic device is showing incriminating evidence, the investigator would photograph it, copy the information onto its storage device. Once the evidence is located to the laboratory, investigators can begin the search of the computer and the evidence. And then you can copy the suspect's hard drive to an FTK. In case, making sure that the drive is write protected. And then the chain of custody, which you want to make I've seen a lot of places, a lot of departments use the little tags that stick on it, and then the investigator would write his name and put a piece of evidence tape over it, so that way it wouldn't be broken. And if it is broken, you know that it was tampered with, or the chain of custody is broken. And the chain of custody is anybody who comes into contact with it or touches it or has to look at it for some reason has to fill out a chain of custody piece of information. It's important because when you go to court, you want to show that you had a proper chain of custody, that it wasn't unbroken, that it was all the way through, and then it wasn't tampered with. All right, and I think that's about it. Thank you.